there are different techniques of, resolving disputes. And these techniques will include negotiation, mediation, expert determination, adjudication, arbitration, and of course, litigation and dispute boards. Now, these techniques, relatively, I think I've mentioned them previously, that negotiation is more of the parties resolving the disputes between themselves, not necessarily involving a third party. They just want to assess and appraise the situation by themselves, look at the facts around their disagreement, and reach a resolution of the disputes, and they move on. Mediation requires an independent to actually look at bringing in an independent party to look at the make decision based on the matter before the mediator or the conciliator. And of course, expert determination is also involving a third party who is an expert. And of course, his decision on whatever he assessed is final. It's like somebody that is sick. You need a doctor to diagnose, a medical doctor to diagnose and establish that, okay, this is the way to treat the person. So you not call an accountant to do that, because that is not his expertise. So that is the concept of expert determination. Adjudication is actually following a particular act. There are adjudication acts in countries that will require that once there is disagreement, and of course the parties to the contract request an adjudication process to resolve their dispute. The idea is once the party has served the notice of adjudication, the adjudicator should act, having received the notice of dispute within 28 days, So that is becoming more formal, The decision of adjudication is also binding in most cases. So there are times that you could have flaws in decision of adjudication, and of course, it may and of course, especially it is binding and is enforceable. For application to apply, they would have agreed to contract that once disputes, issue occurred or happened between them, then within the contract, they have agreed that they are going to resolve it by arbitration. That means within the consortium contract, the parties would have inserted that clause that once there is difference, it should be resolved by arbitration. For litigation, as earlier mentioned, it requires civil procedure. And the decision of the judge is binding. It is about proving rights. And of course, the need for mutual understanding of. All right. In fact, one of the problems with litigation, after litigation, that exists between the parties may be jeopardized. You know, that is one of the reasons why we have the dispute resolution method. Another one that we have, as earlier explained, the dispute board is either it is dispute review or recommendation board, or you have dispute adjudication boards. The focus on dispute board is that as you commence the construction works, the board would have been established and they will be involved relatively in assessing contract documents, transaction between the parties. And at the same time, they visit the sites from time to time as may be required. They visit the site. So in this case, the dispute adjudication board is a relatively different form to the dispute resolution or dispute recommendation board. Often, the recommendation are used to resolve dispute between the parties, thus avoiding formal disputes. On the other hand, dispute adjudication board follow a very similar pattern, but they make formal written decisions which bind the parties in respect of any dispute that arise. So the DRB, Dispute Recommendation Board, and the DAB, Dispute Adjudication Board, the major difference between them is that the DRB avoids escalation of issues to becoming a full-blown dispute, while the DAB, the Dispute Adjudication Boards, the resolution of the Dispute Adjudication Boards is usually binding on the parties because they are going to write formal written decisions which will be binding on the parties. So having a more grounded understanding of ADR, we should understand from what we have discussed that the ADR is more of looking at a better way of resolving disputes. It's like looking at a better way of resolving disputes. And once we establish the formal way, that better way, that means we are looking at resolving it such that the parties to the contract, they are going to have a faster way so that issues will not be delayed. The dispute is resolved faster, and of course, the relationship between the parties in terms of good relation is maintained. So in maintaining the relationship between the party. The whole idea about ADR is to ensure that we have something that will make the arrangement between the party easier and avoid unnecessary time wastage, in managing the contract between the parties. Sorry.